see everyone slowly sitting down, so I just want to say a quick hello and welcome to all of our guests tonight at the next Budapest Lectures session. And without further ado, I want to say a couple of words about our guest tonight. Justice April Farris from the Texas First Court of Appeals, a lawyer of many professional backgrounds, is with us tonight. It's her first time in Hungary and in Budapest, and she's going to talk with us about law and justice in the United States. And to instantly use a metaphor from the Supreme Court language, this topic might be a little bit too vague and overbroad, but we have a lot of ground to cover tonight. And I just want to say maybe two things about our guest. She has worked in private practice as an attorney. She's worked in public administration as the Assistant Solicitor General for the state of Texas. And right now, she's on the First Court of Appeals, if I remember well. And I think, and I'm going to cut into my first question here, it is a standard, a very high standard of any professional experience if one is referred to as super. And if my information is correct, you have been called a super lawyer by Law 360, which is a legal NGO, a news outlet that does work in the legal field. And you've also been named or put on the list of best lawyers of America. And my first question would be, in the abstract, based on the different roles that you had as a professional, what would you say are the qualities of a super lawyer?
Well, to begin, I'd like to thank you all for having us. We're actually on our 15-year anniversary. Wanted to come over to Europe and see some sights, and we really appreciate the courtesy and hospitality, and it's been really fun getting to see the Curia and learn how things are done over here in Hungary. That's a great question. I think part of being a good lawyer is, having a real passion for the law and having a real, kind of fire for learning and studying and always kind of improving your craft. And so whenever I, find out that somebody's interested in going to law school, I talk to them and I, say, okay, does brief writing really, light you on fire, or, do you enjoy getting up and advocating in front of a court, and so I think passion's a big part of it. And then beyond passion, just having the dedication to really keep looking until you find the right answer. And so I find a lot of amazing lawyers happen to be very gifted researchers. They probably could have done tremendous research in any number of fields. And some of them are, patent lawyers with science backgrounds, things like that. But if you love research and you love the law, you're going to do great. So.
The love of research is certainly something I can understand as an academic. So right now, in the name of in-depth research, we're going to cut a little deeper. In your judicial philosophy, which is publicly accessible on many websites that I read, you say that you refuse to legislate from the bench. And obviously my first question is, how should we understand this exactly? But I'm going to put this into context for our audience as well. Because there's a lot of talk recently about whether judicial activism is something that's good or bad. And as it translates, for example, to my field of research, which is constitutional law, obviously there's talk about originalism or living constitutionalism. And as a judge with the judicial persona you're thinking with right now, what would be your stance on how courts should interpret the law and the Constitution? Because it has been a very significant topic in current constitutional discourse, this whole idea of how judges should look at the law.
That's a great question. So in the United States, there's been a debate over how we, as judges, how we look at the Constitution and whether we look at it as an originalist, which means we view the Constitution as having a fixed meaning, having the same meaning that it had whenever it was enacted. And then there's a different school of thought, living constitutionalism, which believes that the Constitution takes on the meaning that it has at the time that you're looking at it. And so it's more viewing the document as a set of guideposts, and then we bring our modern understanding to, you know, what those words should mean. And I find myself in the originalist camp for a couple of reasons. And I guess the biggest one is kind of as a matter of judicial humility. Whenever you find something is a constitutional right, you're taking away the people's ability to vote on that. And so we're not legislators, we're judges, we haven't been elected to be legislators. And so when you take the view that the Constitution has a fixed meaning, then it just becomes our job to say what that meaning is. And if people don't like that meaning anymore, then they have the opportunity to change the Constitution. And by doing that, we reserve the most power to the people to exercise self-determination. And one thing that I find very interesting, being a Texas judge, is we have a Texas Constitution. And the American Constitution has, many provisions that have been imported wholesale into the Texas Constitution. But the American Constitution, is a very old document. It hasn't been amended in decades. And it's kind of viewed almost religiously, like, this is the Constitution. It doesn't change. And so I think because it's very hard to amend the Constitution, there's a bigger temptation to read things into it that aren't there, that maybe you'd like to be there, but certainly weren't there at the time that the framers put the words on paper. But the Texas Constitution has never been treated in that way. So the Texas Constitution is much easier to amend. In fact, we amended almost every legislative cycle by putting new provisions on the ballot directly for the people. And so the Texas Constitution has been amended over 500 times. And whenever we're looking at the Texas Constitution, it's very easy to look and say, well, what did this mean when the drafters put the words on paper? And if we don't like that meaning, then let's just go, next cycle and fix it. So that may be, part of the temptation is just how hard it is to actually amend the U.S. Constitution that makes people decide to, read things into it that, the framers certainly never would have contemplated.
Thank you. So right now, I think we see it a little bit clearer what it means not to become a legislator from the bench. But this question also has another angle that I want to ask you about right now, and it is related to separation, distribution of powers. Obviously, there's an executive, a legislative, and a judiciary branch. And there's been a lot of debate, especially in Central Eastern Europe or in the context of Central Eastern Europe these days, about the rule of law and separation of powers. And our courts are very often, some of our courts are very often attacked with the indicators captured, for example. Captured by the ruling elites. There is talk, at least as far as I know, in the US as well, about a Biden commission, if I'm not mistaken, that talks about Supreme Court reform under the auspices of a similar thinking about the court being captured. And based on your professional experience or your insight, what is the expected outcome of this process for the US?
It's been a subject of debate, for a long time, and I wouldn't begin to predict how it's eventually going to come out. But I think what that speaks to is the level of power that courts hold in the United States. Because as I said before, when you decide that something is a constitutional right, you're necessarily taking away the people's power to vote on that particular issue for all time. And so that makes everyone care to an extraordinary degree about who's on the court, what the makeup of power is between, the justices. And that kind of elevates the courts, at least in the United States, to a position of very important prominence, because these are the people who ultimately decide what you can vote on and what you can't vote on. And so that's at least how it shakes out in America.
In the talks that we had preparing for this lecture, you mentioned something that you called regulatory capture. Can you expand on that just a little?
Yes. So in America, and again, I'm not going to take sides on whether there is such thing as regulatory or capture or not, but there's concern about whether agencies are being regulated by or whether basically there's too much kind of palling around between agencies and the people who regulate them. But that's, when you use the term capture, that's at least what people in the United States think. But as a judge, actually, at least in Texas, I'm not allowed to take policy positions on various issues. But I can tell you that that's at least a debate that they're having in the United States right now.
This was an unintended but a very nice segue into our next question. And I'm also referring back to your judicial philosophy, in which you say that the foremost judicial qualities are impartiality and independence. And connecting this with freedom of speech and all the issues that we talked about before, the obvious question comes to mind: in light of most recent debates on the frontiers of the First Amendment, which covers free speech, what sort of ethical and professional constraints being a member of the legal profession comes with or entails, and whether these are different for the different branches of the profession?
Sure. So at least in the United States, we have the First Amendment, which guarantees the right to free speech, but that only guarantees your right as against the government. It doesn't, say that you can go and say anything to your employer or tell your employer to take a hike and you won't get fired. That's not what that means. So you have the First Amendment as kind of the basic foundational level that the government's not going to throw you in prison for holding a particular opinion. But attorneys are held to a higher standard of conduct. There's things that you're not allowed to say when you're in court. For example, you can't behave in an unprofessional manner. You can't call your opposing counsel names or make unfounded accusations, things like that. And then as a judge, there's Texas Code of Judicial Ethics, and that says you're not allowed to do anything that would bring the judiciary into disrepute. And so I found, for example, I'm always very careful in putting my thoughts together before I say things, because there's people out there who will enforce that code of judicial conduct, and it's important. And I do think it brings out the best in the judiciary, because again, we're not legislators, we're not policymakers. We're charged with the very important duty of saying what the law is and not what the law should be. So.
I'm going to have a follow-up on this, because I know that you worked in technology, and since we talk about freedom of speech and the constraints that it has, based on your past experience back when you were an attorney, what would you say are the core issues right now for the hot topic that we call platform regulation and online freedom of speech?
So Section 230 is a law that regulates platform companies, and that's been a hot topic in Congress, but also, in the courts, there have been all kinds of questions about, First Amendment issues, what can be said, are they private entities? So there's all these, big discussions that are having, and courts are having to step in and weigh in on, competing views of speech rights. And so it's an exciting time to be following those issues in the U.S. courts.
It definitely is, but just for the sake of our audience, let's expand a little bit on Section 230. It's from the Communications Decency Act that was adopted, I think, in the Clinton era, maybe 1996-ish, and it is relevant to limiting platforms' liabilities for third-party content, if I'm not mistaken.
That is correct.
What's the issue about this that's in the discourse right now?
So basically there's just a lot of debate about whether what we have offers enough protections, or whether it should be doing more. But again, that's something that the legislature is ultimately going to have to determine, and then the courts will be charged with carrying out whatever the legislature ultimately decides. But you can. There are just reams and reams of articles talking about, whether this law that was passed, kind of at the birth of the internet, is really up to speed with, this modern connected economy where our entire lives are online now.
Absolutely. And I'm sorry for putting you on the spot. I know you don't legislate from the bench. I just wanted to expand a little on what Section 230 means so that our audience also catches up with us. Also, something else I want to ask you about. When I got to know that you're going to be the one that I'm moderating tonight, I read up a little bit on you. And when I prepared, I noticed a couple of articles that had an angle that approached you and your career from the, and I'm coming back to the career angle just for a bit, that approached you and your career from the angle of, if I may be so bold, the female legal experience. I'm asking you right now, is there such a thing at all? And if there is, what's your take on the female legal experience based on your previous roles and your current role?
I certainly think there is such thing as the female legal experience. Many of us, come up through law school and go into our careers knowing that eventually we'd like to have a family, and that's going to entail, making time for children, making time for the responsibilities that come along with family life. And I encourage women to pursue a career in the law because I think it's a fantastic career that really needs more women, because especially when you consider that probably half your clients are going to be female, you want to be able to relate and to be able to deliver effective representation. But one thing that I found throughout my career is just because you're a woman, just because you're a mom, that doesn't necessarily mean that that you're the one taking off for the doctor's appointment, or you're the one taking off when somebody's sick at home. My husband is a school teacher, and we have traded off and made time for our family to make it work the way we want it to. And so after I had my second child, my husband took a year off so that I could be an effective partner, and then I could come to the bench, and it's a balance. And so I'd encourage men and women that the biggest choice that you're going to make in your career ultimately is who you decide to spend your life with. So make sure you make a good decision, make sure you're on the same page, and then work with each other to so that you can both fulfill your professional goals as well.
Thank you. And I also a follow-up to this. There's a lot of debate right now in Hungary about how the government, or whether the government or the state should help families or achieve work-life balance, things like that. And we've talked a little bit about this regarding the Hungarian situation, but how would you say, or how would you reflect on how the American legislature or the state helps you achieve these goals?
Well, one thing that at least my employer helped with was we had a fantastic parental leave policy. So, for example, when I had my second child, I had 3 months that I could take off, and it was fully paid. And they were very flexible. I had 2 major oral arguments, one in the Sixth Circuit and one in the Texas Supreme Court, that came up while I was on maternity leave. And I really wanted to be the one to argue those cases. And they made it possible for me to work up the case, to do my argument, and ended up winning both cases. But they let me make up the time that I spent at work on the backside of that. And, that it just made me so happy and so fulfilled to be able to, spend time with my children, but also to be able to win a multi-million-dollar case up in the Sixth Circuit without being penalized by losing, that time with my child. So that was wonderful, and it's something that absolutely makes a huge difference, I think, for working women. So.
And how does COVID, if it does at all, help you within your new capacity? I mean, obviously, it might have given you a different appreciation of the judicial bench, you starting recently. How does COVID and the whole pandemic prevention affect the daily judicial work? What are the symptoms?
COVID has had a huge impact on our Texas judiciary, and in fact, Our Texas Supreme Court especially has really gone out of its way to issue orders that give courts the most flexibility to do their jobs that they can possibly have. And so our court, for example, has moved all of our arguments to Zoom. We're probably going to go back to in-person oral arguments pretty soon now that our numbers are doing so much better. But for appellate courts, like we haven't missed a beat because it's so easy to, just have the litigants log in on Zoom, and our caseloads are still where they were before COVID, and that's all been due to the rise of technology. And it's funny because I don't know if courts in Hungary are this way, but at least in the United States, courts are not necessarily early technological adapters. And COVID's been horrible and has been such a sad and traumatic experience for the country. But if there is one kind of ray of light that's come out of it, it's that the courts have really been forced to modernize in a way that I don't think they ever would have done on their own, but for COVID, at least over here.
Absolutely, modernization is something that was really helped with this unfortunate turn of events. You said that. When we were preparing, we discussed what the possible differences between Hungary and U.S. in what appellate courts do or how they operate, and our regional appellate courts that are similar to your appellate courts cover 5 counties in a country that has a population of 10 million. How different your case allocation is than from what you experienced in Hungary based on your talks, and what's the workload, how many people you work with, because those would be interesting numbers for a comparison for our audience here, I'm thinking.
Yeah, so I'm a state judge in Texas. I'm on the First Court of Appeals. And our court covers 10 counties, including Harris County, which is one of the largest counties in the nation. It's where Houston, Texas is. It's also one of the most diverse counties. So we have over 4 million people in our jurisdiction. And there are 2 appellate courts, which is really strange. It really doesn't make much sense at all. But we have 2 appellate courts. The 1st and the 14th. Instead of expanding the 1st to include 18 judges, they just made a 2nd court that also has 9 judges. We're in the same building. We have the exact same jurisdiction, but we don't review each other's decisions, and we're not bound by each other's decisions, and you don't know which court you're going to get. So that's an interesting nuance of the Texas system. But we hear everything. We hear criminal, we hear family, we hear civil. And so all of the decisions from that entire region are filtering up through those 2 courts. And so it keeps us very, very busy. We set, officially on our docket probably between, 6 and 8 cases per week. But in addition to those cases, we're handling mandamus filings that come in. We're handling orders. We're just, busy all the time. With a populace that large, it just creates a huge volume of cases. So that's been, it's been exciting, but it's been the biggest honor of a lifetime to get to serve, and it's just an absolute dream job, especially for someone who grew up, wanting to be a judge, and it's been a really good experience. So thank you so much for inviting me to come and learn about your system. We toured the Curia today, and it was just absolutely fascinating to learn how things operate over here.
Absolutely welcome. And maybe one question relating to this, if I may. Where to next?
Where to next? I'm planning to stay put for as long as I can. I'm doing the work that I love to do, and I have fantastic colleagues and a great staff, and it's been a dream job.
Perfect. Before we started, I just now realized I forgot to mention that we have an online surface if any of you in the audience want to ask questions, or if you want to do it now in person, that's also a possibility.
Thank you so much, Your Honor, for being here. I hope that's the right expression.
Yes, thank you.
Okay, good. I have the privilege of being a dual citizen of the United States and Poland, so I would like to go back to this question of the rhetoric around rule of law in Central Europe, and by no means do I profess to be an expert on judicial topics in Poland or the United States, but in your opinion, when we see situations with Poland drawing worldwide outrage over its judicial maneuverings, and then we see the administration in the United States having a study to determine whether packing the Supreme Court is something they want to pursue. Is it overly simplistic to look at them the same way and regard it as naked hypocrisy? Or if there are nuances to that, I would really appreciate your thoughts on those.
Oh, you know, it's funny. One of the eccentricities of being a judge in Texas is we're not really allowed to take policy positions on anything because we're not legislators. So I apologize for a very disappointing answer to a very interesting question.
We've had another question here in the first row.
Yes.
Thank you. Two quick questions, actually. First off, thank you for coming. First question is, you've talked about being opposed to legislating from the bench, and you'll be aware of Jonathan Sumption, the former UK Supreme Court Justice, did the BBC Reith Lectures 2 years ago precisely on this issue of the encroachment of the law into politics, or rather the courts into politics, where many questions that he thinks should be left to the Parliament are actually being decided by courts. And do you see this sort of, I suppose it could be called judicial activism perhaps, but do you find this tendency for questions to be moved to the courts and for courts to make law in a sense, do you see it as a growing problem? And if so, how to change that trend? Second question is, you've mentioned the Code of Judicial Conduct, and it does seem to me one of the last, I mean, no offense to Americans in the room, but one of the last bastions of civility in American life seems to be the code of conduct among the judiciary. That there is not the intemperance there that you see in the other branches of American public life. But I wonder, do you see that as beginning to erode? And particularly as it seems that legislative nominations are becoming more and more political in the States.
So to take your first question first, I think what I can say about that is, you know, I think that constitutional interpretation philosophy matters, and at least in America, this concept of originalism really does try to hold you to keeping the law to what it was when it was written down, and not giving judges a lot of room to maneuver. And so when judges have less room to you know, kind of create new law that the legislature didn't see fit to enact, that's where at least I think judges get into trouble. And so I really try to adhere to the text and to do my best to you know, uphold and defend the Constitution as I believe it was enacted. So you know, that's my personal check on that. And I think judges come down in different ways, but in terms of courts staying in their lane, I think judicial philosophy is the best way to make that happen. And then I think the politicization of courts is something that, you know, no one wants to see. Everyone wants judges to do their jobs, to enforce or to defend the Constitution and to read it fairly. And I think that, you know, one of the most important things that you can do as a judge is be impartial and not let whatever your personal political beliefs are cause you to step outside your lane and try to create law that the legislature hasn't seen fit to enact.
Any other questions? Well, another one in the first row.
Okay, so thank you very much for coming, first of all. My question would be that there are many controversial cases before the Supreme Court this segment or semester, and one of those cases is the Mississippi law that is restricting abortion. That would seem that it goes against the Roe v. Wade ruling. So how do you see there is a chance that Roe v. Wade would be overturned, or maybe this
That's
is
another very interesting question
right?
that I'm not allowed to answer.
Yeah, but maybe from a different perspective. There are many... so let me rephrase the question. Maybe that's better. So that there are many questions about the politicization of the Supreme Court, that there are many conservative judges. In this case, for example, Justice Thomas. How do you see that this is a reality, or this is more of a political, I don't know, messaging that the judges are in fact independent and not the puppets of presidents?
You know, it's everyone knows, you know, having read the writings of, you know, different judges where they come out on viewing, you know, abortion constitutional limitations. But, you know, to say how it's ultimately going to come out is pretty far above my pay grade at this point. But it won't be long, so stay tuned, and that decision will be coming down anytime now. So,
thank you.
Seems we have a tough crowd tonight. Any other questions? It's by Anonymous. Should the judges strike down a morally reprehensible but constitutional law? Should morality play any role in a judge's decision?
Oh my goodness.
Thank you, online free speech.
Online free speech. I mean, going back to not legislating from the bench, it's our job to decide what the Constitution says and to enact what the legislature enacted. And ultimately, if we were called to use our policy positions, then we would be legislators. And so I think part of being independent is being able to do your job and to try to faithfully adhere to the text without, even sometimes when it doesn't go. I've had plenty of decisions where, you know, the case didn't necessarily come out the way that I wanted it to come out, but the law, you know, says what it says, and that's what I'm there to do at the end of the day.
Absolutely. Thank you very much. Another anonymous. When Biden was elected, some feared that he would try to increase the number of judges of the Supreme Court. Do you see it as a realistic scenario?
So that's a good question. You know, it's certainly something that people are talking a lot about. I have no special insight as to whether that will ultimately be a reality, but you know, it's certainly a conversation that's out there.
And I don't see any more questions, neither on the online platform, neither here in the room. So thank you very much for being with us and for asking the tough questions. And I think it will be a very memorable anniversary trip, spiced with the Budapest Lectures, with this very wonderful audience. I just want to thank you and our guest as well for attending and being here with us tonight. And I think we deserve a round of applause.
Thank you so much for having me.